everyone, I hope you are all having a fantastic day. Today, we are diving into the general provisions of the revised rules on evidence. We are excited to share valuable insights with you and hope you find it informative and engaging. Our group will discuss the definition of evidence, including its scope, admissibility and relevance, and collateral matters. We will delve into these key concepts to better understand how they shape legal proceedings and their implications. As we explore the general provisions of the revised rules on evidence, we will highlight the key concepts that every aspiring lawyer must grasp to navigate legal disputes effectively. By understanding these provisions, we can ensure that we are equipped to uphold the integrity of judicial process and contribute to the administration of justice in the Philippines. And we hope that through this discussion, we gain more understanding of the relevance of these rules in our legal system. Enjoy watching!
According to Section 1, Rule 128 of the Rules of Court, evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. This succinct statement highlights three critical elements. The means refers to mode or method accepted by law to prove the existence or non-existence of a fact. Sanctioned by these rules underscores that only evidence allowed by the rules of court may be used in court. Ascertaining the truth emphasizes that the ultimate purpose of evidence is to guide the court in discovering the truth of disputed factual issues. Evidence is required because of the presumption that the court is not aware of the veracity of the facts involved in a case. It is therefore incumbent upon the parties to prove a fact in issue through the presentation of admissible evidence. While the purpose of evidence is to know the truth referred to in the definition is not necessarily the actual truth, but one aptly referred to as the judicial or the legal truth. When evidence is not required. When no factual issue exists in a case, there is no need to present evidence because when the case presents a question of law, such question is resolved by the mere application of relevant statutes or rules of this jurisdiction to which no evidence is required. In the Philippine judicial system, there is a mandatory judicial notice of the official acts of the legislature, and these acts cover statutes. When the pleadings in a civil case do not tender an issue of fact, a trial need not to be conducted since there is no more reason to present evidence. Evidence may likewise be dispensed with by the agreement of the parties. Evidence is not also required on matters of judicial notice and on matters judicially admitted. The rules of evidence, being part of the rules of court, apply only to judicial proceedings. It has been held that administrative bodies are not bound by the technical niceties of the rules obtaining in a court of law.
The rules on evidence form an essential component of the rules of court, and they are primarily applicable only to judicial proceedings. These rules ensure fairness, order, and consistency in the presentation and assessment of evidence in court. Rule 128, Section 2 of the Revised Rules on Evidence explicitly states the rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. This provision reflects the principle of uniformity, meaning that, as a general rule, the same standards and procedures for presenting evidence apply across all courts and in all types of trials and hearings. However, there are specific exceptions to this principle. Section 4, Rule 1 of the Rules of Court provides that the rules on evidence do not apply to certain special proceedings including 1. Naturalization proceedings, 2. Insolvency proceedings, 3. Cadastral proceedings, 4. Other cases as may be provided by law, 5. Land registration cases, and 6. Election cases. In addition to these, the rules on evidence are also inapplicable during the course of preliminary investigations. In the case of Estrada versus Ombudsman, the court ruled that hearsay evidence is admissible in determining probable cause during preliminary investigations. This is because such investigations are merely preliminary in nature and do not constitute a final adjudication of rights and obligations. Moreover, these rules do not apply to proceedings before the National Labor Relations Commission or the NLRC, as held in the case of Buenaflor Car Services versus David. Finally, it is important to note that the rules on evidence may, under certain circumstances, be waived during trial. However, if a particular rule of evidence is founded on grounds of public policy, any attempt to waive it is considered void and unenforceable.
Section 3, Rule 128 of the Rules of Court defines the admissibility of evidence. Evidence is admissible when it is relevant to the issue and not excluded by the Constitution, the law, or these rules. The exclusionary rule under the Constitution was included, but even before the amendment, the term law was understood to encompass the Constitution. The following are the requisites of the admissibility of evidence. First, it must be relevant to the issue sought to be proved, and second, it must be competent or not otherwise excluded by the Constitution, the law, or these rules. Relevant evidence is a kind of evidence which has relation to the facts in issue. There is no precise and universal test of relevancy provided by law. Determination of relevancy is largely at the discretion of the court in accordance to the teachings of logic and everyday experience. Relevance is a matter of relationship between the evidence and the fact in issue. The determination of relevance is a matter of inference and not of law. As a general rule, only relevant evidence is admissible and the collateral matter is not allowed. However, collateral matters may be allowed when tends in any reasonable degree to establish the probability or improbability of the facts in issue.
Competent evidence. Competent evidence is one that is not excluded by the Constitution, law, or rules in a particular case. The test of competence is the laws or rules. In relation to evidence in general, competence refers to the eligibility of an evidence to be received as such. When applied to a witness, competence refers to the qualification of the witness. The objection should specify the ground for its incompetence, such as leading, hearsay, or parole. In the case of Jokno versus Stonehill, the court laid down the principle that material seized by virtue of a general search warrant is violative of the constitutional rights against unreasonable searches and seizure, which requires that a warrant should particularly describe the place to be searched and person and things to be seized. Any evidence obtained in violation of this right shall not be admissible for any purpose in any proceedings. To test to determine admissibility, the purpose to which the evidence is offered must be considered. Evidence may be admissible for one purpose and inadmissible for another.
Kinds of admissibility of evidence. First is the multiple admissibility. Where the evidence is relevant and competent for two or more purposes, such evidence must be admitted for any of all the purposes for which it was offered. Examples are the declaration of a dying person, part of the res gestae, or declaration against interest. Evidence may also be admissible against one party but not against the other. It must be remembered that the purpose for which the evidence is offered must be specified because such evidence may be admissible for several purposes. Second is the conditional admissibility. Where the evidence at the time of its offer appears to be immaterial or irrelevant unless it is connected with the other facts to be subsequently proved, such evidence may be admitted on the condition that other facts shall be proved thereafter. The third kind of evidence is the curative admissibility. This doctrine treats upon the right of a party to introduce incompetent evidence in his behalf where the court admitted the same kind of evidence adduced by the adverse party.
Time to determine admissibility of evidence. Number 1, at the time it is offered to the court and must be offered orally. Number 2, in case of documentary or object evidence, when it is presented to the court for viewing or evaluation. Number 3, in case of testimonial evidence, at the time the witness is called at the witness stand or to testify. Number 4, in case of documentary evidence, when it is formally offered and before resting of the case.
Section 4. Relevancy. Collateral matters. Evidence must have such a relation to the fact and issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the facts in issue. First, let's reiterate. Relevance refers to the connection between the evidence in the fact and issue, the fact that needs to be proven or disproven in the case. So the question is, how do we determine relevancy? Evidence is considered relevant first if it has a tendency to make a fact more probable or less probable than it would be without that evidence. It is of a lesser degree of reliability as evidence than material evidence. Material evidence directly proves a fact in issue. Thus, the testimony of eyewitness to the commission of a crime is material. The evidence of motive or flight of the accused may be relevant. Second, evidence that is material or relevant must also be competent to be admissible. For example, although the testimony of the eyewitness may be material, it may be inadmissible if it excluded by the material disqualification rule. Relevancy or materiality of the evidence is a matter of logic, since it is determined simply by ascertaining its logical connection to a fact and issue in the case. Collateral matters are unrelated issues or facts that are not directly related to the fact and issue. As explicitly stated, the rules excluded collateral matters from being admitted as evidence unless they help establish the probability or improbability of the fact and issue. As a general rule, collateral evidence like the defendant's prior criminal history would not be allowed because it doesn't help prove whether or not the defendant committed the crime. It is unrelated to the specific act being tried. However, the prosecution might be allowed to introduce evidence of the defendant's prior similar conduct if it can help establish a pattern or intent relevant to the current case.
So let's discuss the case of Atienza versus Board of Medicine. The chronology of events leading to the Supreme Court's examination of this case involves a surgical procedure gone awry and the subsequent legal battle that traversed the Philippine legal system. Edita Shoson, experiencing lumbar pains, sought medical attention at the Rizal Medical Center in 1995 and was operated on in 1999 for non-functioning left kidney. During the post-operation, it was discovered that her functioning right kidney was removed instead of the left kidney. Thus, her husband filed a complaint for gross negligence against the attending physicians, including Rico Atienza. During the administrative proceedings before the Board of Medicine, Shoson presented exhibits to prove that her kidneys were in their anatomical locations at the time of the operations. Despite objections from the petitioner on the grounds of inadmissibility, the Board of Medicine admitted these exhibits. Atienza argued that the evidence offered by Shoson violates the best evidence rule, have not been properly identified and authenticated, completely hearsay, and incompetent to prove their purpose. Atienza's motion for reconsideration was denied, leading him to challenge the Board of Medicine's order through a petition for certiorari. So the issue in this case, is CA correct in affirming the decisions of the Board of Medicine? So the Supreme Court upheld the CA's decision affirming the Board of Medicine's orders. The court differentiated the admissibility of evidence from its probative value and reiterated that administrative bodies like the BUM are not bound by strict rules of evidence. Admissibility refers to the question of whether or not the evidence is to be considered at all, while probative value of evidence refers to the question of whether or not it proves an issue. The decision emphasized that admission of Shoson's exhibits did not prejudice the substantive rights of Atienza. The anatomical locations of Shoson's kidneys are facts that require no further proof as they are presumed under judicial notice.
The general provisions of the revised rules on evidence serve as a fundamental framework for understanding the crucial role of evidence in shaping the legal system. These provisions are designed to uphold fairness, ensure clarity, and enhance the efficiency of legal proceedings. By establishing clear guidelines on the admissibility and weight of evidence, they contribute to a more just and effective judicial process. We hope that this discussion has provided valuable insights and deepened your understanding of the essential aspect of the rules of court.